Hello, everybody.
This is in the District Court of Butler County, Kansas, case entitled Alternative Electric LLC Plaintiff versus Boeing U.S. Holdco Incorporated, Jaeger Construction Group LLC, and Hartford Fire Insurance Company defendants, case number 2024 CV 128. Beginning with plaintiff, would counsel announce their appearances for the record, please?
Your Honor, Eric Bruce on behalf of Alternative Electric.
May it please the court, Your Honor, Patrick Edwards, and I also have Marisol Garcia in the room with me on behalf of defendant Boeing U.S. Holdco.
Your Honor, can you hear me okay?
I can.
Oh, great. Thank you. I apologize for interrupting. Heather Shore on behalf of the surety.
And Your Honor, please court and counsel, defendant Jaeger Construction Group LLC appears through counsel Terry Malone.
All right. Counsel, this matter is scheduled to come before the court this morning for status conference. Court's just going to refer to its notes from our last conference on December the 12th of 2024. At that time, the court noted that Malone's extension to reply was granted to 12/27 of 24. Discovery deadline generally extended to February 15 of 2025. All reasonable efforts to be made to complete corporate representative depositions in January of 2025. Court ordered a mediation settlement conference with time, place, and manner to be determined by the parties, but to be before any trial date is set. And Mr. Edwards was to journalize that. And then the Zoom conference was set for today. All right. Since then, the court notes from the file that there have been a number of motions that have been filed in this case. Have any of those motions been resolved? Mr. Bruce, let me ask you.
No, Your Honor.
Has there been any conferencing regarding any of the issues that are raised in these motions?
Yes, Your Honor. I've talked with Mr. Edwards a couple, 2 or 3 times, and our position is that we're available for depositions. We've provided all the documents that are appropriate and necessary for the matter, and will be available pretty much anytime with a couple exceptions. One is that my client is a master electrician, the only one with his company, and he needs to be there to keep his people on the job. So we've suggested that half days in the afternoon, he'd be available pretty much anytime. We've also suggested that I've been told that we needed to produce payroll records. We've produced payroll records, but we haven't produced each payroll sheet for each employee, nor have we produced copies of the receipts for invoices for purchase of equipment that was used on the job. We don't think those are necessary for the determination of the matter, and we leave that to the discretion of the court.
All right.
Your Honor, I would like to respond to that on behalf of the surety. I have sent, I don't know, not less than 10 emails to Mr. Bruce after verbally having a discussion during the deposition. He doesn't respond to me. Last I checked, my client's been sued, and I'm a defendant in this case, and so it's very hard to have a one-way conversation. So no, we've not resolved the issues because I cannot get Mr. Bruce to even have the courtesy of responding to me. I'm not asking for a lot. I'm just very confused about the documents and how they were produced. There were certificates of service stating that my office had received documents when we hadn't. And I don't need a lot in this case. I just am a very organized person, and it's been very difficult to manage the information in the way it's coming in. And then there just seems to be a lack of communication.
Mr. Bruce, can you address this communication issue?
I'll try. I think the problem is whether the communication is directed to me or to my secretary. And I think there's been some communication that's gone to my secretary that hasn't reached me. And as far as discussing matters with Ms. Shore, I'm ready to do that most any time.
Well, not according to her, Mr. Bruce.
I understand that, and I think that what's happened, like I said, is that she's been emailing Van, who's my secretary, and that hasn't been getting to me.
Ms. Shore, is that true?
No, I mean, there's a lot of case law out there that says that we as lawyers cannot delegate duties to secretaries and then blame them. And I personally, I don't know anything about that. I can just tell you that I'm emailing with an address that has his name on it. I've had other attorneys in this case email me independently and say, he doesn't seem to respond to you. Is he cutting us off, from the responses? Would you share them with us? So I don't want to get in a situation where, I'm questioning somebody's integrity or his secretary. I'm sure she's doing the best she can. The bottom line is we just need to be able to communicate with one another and respond to each other. And we're creating more fees and costs and time for the clients and the courts due to this lack of organization, lack of communication. It's not that, it doesn't need to be that big of a deal. I put in my motion exactly what I would like, and I just respectfully ask that the court order Mr. Bruce to take some time and respond to my request to get the certificates of service cleaned up, and then to please send me documents that he claims he has served on everybody. That's really all I need.
And I'd be glad to do that. And I will do that. And if you communicate with me through eBruce, that's the way to get me.
You have that email address, Ms. Shore?
Yes, Your Honor, that's the email that I have sent probably 6, 7, 8 emails to. Yes, correct.
Well, I just recall, in ancient times when this court used to practice, we had something called a telephone. And I know it's an archaic thing, but you dial it and you actually talk to the lawyer on the other end. And I don't know if that's technology that's still available or not, but I might suggest that if it is, that you try doing that once in a while.
Your Honor,
I receive so many electronic messages in a day. Occasionally I miss one despite my diligence. That can be done, I think, by any busy attorney. So sometimes if you're not getting the response you want, I would highly suggest that you just pick up the phone and you call Eric and you let him know what the problem is so that he can address it. But Mr. Bruce, you've made some assurances that I think you're aware of what Heather wants and that you're going to promptly address those concerns. Is that correct?
As promptly as I can, Your Honor, let me note one thing. I'm out of town this week on the grandchildren mobile. I'll be back next week, and I'd be glad to, and I will send an email to Ms. Shore here shortly saying, please respond to me exactly what you need, and I'll try to have it to you next week.
And that's to his point, Your Honor. I'm kind of old fashioned too. I believe in picking up the phone, but that was a request he made of me when we spoke, was send me an email, let me know what it is you need. He was been, very communicative at that point in time. It's just since then, when I send that email, so I'm happy to do it again. And if I don't get a response, I will call Mr. Bruce again. But I agree with you. I think that we do need to have a more personal touch. I'm trying to do what he's asking me to do. I just need to get a response.
All right. Well, I have every impression here that next week you will have that response.
Thank you, Your Honor.
All right.
Thank you, Mr. Bruce.
Thank you.
All right. I have before me a document entitled Boeing's Combined Motion to Compel Complete Document Production by Plaintiff to Extend Discovery Cutoff Deadline, to Extend Summary Judgment Response Deadline, and for award of attorney fees as sanctions, filed by Mr. Edwards.
Yes, Your Honor.
All right. When it comes to deadlines, that's something that is proper to address today. What is your suggested date for extension of a discovery cutoff deadline?
Your Honor, just because we needed to put a date in there in our motion, I believe we proposed June 13th of 2025. That is subject to us getting a complete document production. from Mr. Bruce. I still don't believe, since we had our meet and confer, I need to double check my notes, but we had our meet and confer, I believe, on February 12th. I don't believe, again, I'm subject to me being wrong here on this. I don't believe we've received any additional documents from Mr. Bruce since we spoke. And we just need to close the loop on, our discovery response, or his discovery responses were out of time. So any objections were waived. I believe that all of our requests are completely proper anyway. There's a number of issues here that this was suggested by Mr. Bruce to the court that this is a really simple lawsuit. It's actually not. And I think his motion that he filed, or his response brief that he filed on, I don't have the date in front of me. I apologize. Actually, here I do.
24th.
Yeah, the 24th. I mean, I think it acknowledges that this is not actually a simple, straightforward case anymore. But there's a number of factual issues that we need fleshed out. One is whether the amounts that are being sought in these underlying mechanics liens that are the basis of this lawsuit now, whether they were approved by Jaeger as required under the contract, if they are outside the scope of the original contract amount. Another issue is whether they were that kind of came to light during the deposition that took place in early February, or the partial deposition because it hasn't been completed. Is whether the amounts were reasonable. Now there's a new issue as well that was brought up during that deposition. Mr. Bruce's client raised an issue of a industry practice, or at least I guess it started out as an industry practice, and now it may just be an alternative practice of you don't need written authorization if it's under $10,000. So there's now, I guess, there's a number of issues that this case is expounded and expanded quite a bit just following the partial deposition. And so we need to close the loop on the discovery requests and the responses that have been issued to date. And again, I hope that June 13th or whatever date we identified in our motion is workable. But again, a lot of that is outside of my control. We've got to finish up initial written discovery that for requests that we issued in August before we're able to move forward. Another issue that came up during the deposition was documents were produced both in the middle of the deposition. There was a break during the deposition for that to take place, and as well as the next few days after the deposition, there were additional documents produced. I don't have a whole lot of confidence that we've gotten, even ignoring the issues that Mr. Bruce raised about whether or not certain documents that we're requesting are relevant. I don't think that we have a complete production of everything else that's not in dispute, that there weren't objections to, just based on the way these documents have been produced in this case. So again, I'm trying to do my best. I'm trying to move this along. I'm certainly not trying to drag my feet on discovery or scheduling depositions, but we can't schedule any more depositions, including the completion of alternatives corporate rep, until we have everything. Because at this point, it's just a waste of time if we keep going back every time something new is produced that should have been produced 5 months ago.
All right, we'll deal with this extension of the discovery cutoff deadline to June 13 of 2025 as proposed. Any objection to that extension, Mr. Malone?
No, Your Honor, we're joining in that request.
Ms. Shore?
No, Your Honor, same thing.
Mr. Bruce?
Your Honor, we have produced everything that we think that we have. During the deposition, my client was asked if he had additional emails or anything else. He was also asked about payroll records. He believes that he had previously produced those, but since he couldn't find them right away, he went ahead and we copied and provided those. Now, we have produced all we've got, with the exception, like I say, of additional per employee hourly payroll records. I mean, those could be produced, but I'm not sure that it matters. What we provided for is a spreadsheet that shows the number of hours worked by each employee on each date and how much time they spent. In addition, to The other thing that was requested was copies of the, what I will call purchase receipts, because I'm using that phrase rather than invoices, because there's too many invoices in this case. And I don't want to get the court or the parties confused over that. The purchase receipts where we purchased items that were subsequently used in the project. We have not provided those. A lot of those came out of the warehouse. So, if you have 25 widgets in your warehouse and you use 5, how do you provide a purchase receipt for 5 when you purchased, the 25 that are in your warehouse over however much time? So I can't believe those items or that kind of information is necessary. My client has advised me repeatedly that most of the records that they think we produced at or right after the deposition were records that were included in the original set. Now, it seems to me that they're not wrong that we produced the records in spurts. And perhaps the best way to produce and to resolve this matter would be for us to have a deadline in 2 weeks that says, here is the set of records that we're willing to produce. All of them that we have. And that we be limited at trial to those records. That would move us down the road quickly. And we wouldn't then need to put off depositions or anything else. In addition, I would note that while we've been producing records, Yeager hasn't completed a lot of the email and other kinds of records, nor has there been any deposition of anybody from Yeager. What we believe is that the documents that have already been produced show that Boeing was invoiced by Yeager for the work that we did and was paid. Now they're saying that, well, maybe we shouldn't have been paid. But there is no question but that we didn't get paid ever on the matters that we're dealing with here. And just stretching things out doesn't seem like it helps a whole lot to anybody. That's all I've got, Ron.
All right. Do you have a reply argument to make here, Mr. Edwards?
Yes, I do. A couple things. First of all, the references to Yeager, I think that's entirely irrelevant. Terry and I have been communicating about those matters, and we're trying to work them out. And Mr. Bruce hasn't issued any discovery period in this lawsuit, so it's not related to any discovery that he issued. And again, we're trying to work through the matters with Terry, and I'm hopeful we might be able to. But that whole Yeager issue is a complete red herring. Mr. Bruce's comment that he proposes a deadline in 2 weeks for them to tell us that they've produced everything that, and I didn't take really good notes on what he said, but I think everything that they think is applicable in this lawsuit or something like that. It's not Mr. Bruce's decision on what's applicable and what's not. We issued discovery requests. He failed to respond in time. He waived any objections. Our discovery requests are reasonable and proper anyway. He needs to produce everything that's responsive to our requests. And our motion, or my motion on page 14 running into 15 has 5 Roman numerals as the things that we would like him to confirm. And that's not just that he's produced to us everything that his client has sent to him. That's only part of the story. I want Mr. Bruce to go through, because again, the way this is played out is I don't have a whole lot of confidence we've received everything. And I would like him to go sit down with his client, go request through request, and say, okay, here's what this request is asking for. Here's what it means. What have you done to try to compile documents that exist what have you provided me? What else is there? Provide me with what's else. And then I just want written confirmation that all that's been done, because the piecemeal fashion of this, and the promises that have been made and then broken are just not, I don't have any confidence that we have what has been requested. And again, aside from the fact that Mr. Bruce waived any objections to our requests, our requests are proper. They relate to, if quite frankly, if you don't want to do discovery on this, then don't sue my client for $173,000. That's kind of you can't have it both ways. We're here now, so we're entitled to the documents, not just that Mr. Bruce thinks support his claim, but that are related to the work period. Because we're entitled to conduct discovery to try to poke holes in that if we disagree. And so I just ask that we get, again, a complete production of everything that is responsive, and then written assurance from Mr. Bruce as we request on page 14 going into page 15 of our motion.
All right, Mr. Bruce, you're familiar with these requests made on pages 14 and 15?
I need to look again at them, Your Honor, if I'm going to be claiming to be familiar.
Okay.
That's just the response. If he's talking about from the bottom of page 14 through page 15, I believe that we've done that. Other than the documents that I've indicated to the court today.
All right. The scheduling issue before the court was extension of the discovery cutoff deadline. I'll just note that production of requested documents in spurts necessarily causes delay.
Yeah.
The request for extension of time on the discovery deadline is not on its face unreasonable. Given the specifics of this case, the court is inclined to grant the extension requested to the date requested. Discovery cutoff is extended to June 13, 2025 for all parties. Court also noting that there's still some depositions to be completed and perhaps even noticed up for the first time that would be relevant to the issues of this lawsuit. Additional time is necessary to complete those. And I believe that the time frame suggested by this extension request is reasonable, and the court will grant it. June 13, 2025.
Your Honor, one additional issue that we may or may not need to deal with, but I just want to raise it for the court's attention. And I think Mr. Bruce and I disagree on this point, potentially. And Mr. Bruce, please correct me if I'm wrong. I'm certainly not trying to put words in your mouth there. But I believe that there are some expert issues now that are in play. And so I think Mr. Bruce disagrees with that. But to the extent, I guess, I'm just proposing to the court that perhaps we have, affirmative expert disclosure deadlines for Mr. Bruce, and then to the extent he discloses any, then rebuttal expert disclosure deadlines for the defendants. I'm not trying to create more work, but I do think that there are issues based on what the corporate representative testified to that are expert issues. And I'd like to know if, by X date, if Mr. Bruce doesn't have an expert, then we know, okay, forever and always, he's planning on proceeding without an expert, and we don't have, to the extent we need to file applicable motions, including that he doesn't have expert testimony designated that should have been, that is required for his claims. I think that would be useful and helpful. And I'm just trying to avoid a fight down the road and additional confusion. So I just wanted to throw out there that perhaps we do need expert disclosure deadlines just to kind of close the loop on those issues.
Expert testimony may be required as to what issues here, Mr. Edwards?
Well, one of his defenses, one thing, and this is probably quasi-expert testimony, but I always err on the side of having an expert if it's in that bucket, and that's certainly Mr. Bruce's up to him. But issues on whether or not work that is being sought in this lawsuit is within the original contract scope. Because again, if it's not, then there's another layer of the contractual requirement that has to be approved by Yeager in advance in order to be billed. And so I think that whether something is or is not within the scope of work, for one, additionally, Mr. Bruce's witness testified at his deposition that I believe it started out as it's industry practice, but then it maybe morphed into it's his practice. That if it's under $10,000, you don't have to get additional authorization from your general contractor. Again, if it's to the extent that he's claiming something's industry practice, I think that would fall under expert testimony as well. Those are just a couple things off the top of my head.
Okay.
And again, if Mr. Bruce chooses not to designate an expert, then that's certainly his prerogative. But I would think it might be helpful to say, okay, we know he's made that decision by X date.
I don't have any problem with that.
All right. Initially, this court will establish a deadline for the plaintiff of 28 days from today's date to designate a proposed expert and provide a summary of anticipated testimony and opinions to opposing counsel. Mr. Edwards, how much time after that deadline passes should, of course, an expert be designated, or even if it isn't, for your own deadline for designation of experts and a summary of anticipated testimony and opinions?
It looks like if we do 28 days from today, Your Honor, that puts it at March 31st. Could we have until May 9th, which is a Friday? The Friday, the first full Friday, or first Friday of the first full week in March, or the Friday of the first full week, or sorry, in May. Good Lord, I'm sorry, Your Honor. May 9th, though, is what I was proposing.
Well, that's fine, Mr. Edwards, except that leaves only about a month of discovery deadline period remaining for the scheduling and conducting of that expert's deposition. So I would hope that that May 9th date doesn't cause again another request for extension of the discovery cutoff deadline. That's all. The court's initially going to grant that request. Defendants will have until May 9th to designate their own experts, and again provide a summary of their anticipated testimony and opinions. So March 31 for plaintiff, May 9th for all defendants. Pertinent point, Mr. Edwards.
All right, I'm just trying to avoid fights down the road if we can.
Is the plaintiff still pursuing a motion for summary judgment, either partial or total, in regards to any defendant in the case?
Your Honor, our position is that the documents show that the work that we did has been paid for by Boeing to Jaeger. And that in and of itself constitutes an acceptance of the work. And therefore, we think summary judgment is appropriate on the issue of whether the work was done.
Okay. So I think your answer is yes, you're still pursuing it.
Yes.
There were some procedural deficiencies pointed out, I think, in one or more responses, Mr. Bruce. And obviously, that's not set for hearing today.
Right.
And I believe that there's actually a request to extend the response deadline. Are you still pursuing that, Mr. Edwards?
Yes, Your Honor. And I believe that both Heather and Terry have joined in that request as well.
Yes.
Your Honor, I've indicated that I had a willingness to do that if they could schedule up some depositions to get the thing closed out. That was my position all along.
All right. For the record here, Mr. Edwards, propose your new response deadline on the motion for summary judgment filed by Mr. Bruce.
Yes, Your Honor. We ask for 21 days after the last deposition transcript is prepared in discovery in this case. That's essentially our request, is that we're entitled to do discovery. I think there's a procedural deficiencies aside, I think there are a bunch of disputes of material fact here, genuine issues of material fact that the lone incomplete deposition is shown. And I think there's the more depositions we conduct, the more factual disputes are going to arise. So we just asked to be able to complete discovery in this case and get back the last of the transcripts and then respond to the summary judgment motion.
I trust Ms. Shore and Mr. Malone agree.
Your Honor, yes, I agree. I think that's appropriate because we were the ones that filed the response and pointed out procedural deficiencies. But, we want to also address this on the merits if possible. So if we get the deposition transcript, we should be able to demonstrate to you what the disputes are versus just saying that there are disputes. I think you're going to want to see and identify what issues are in dispute.
Difficulty in that is establishing an uncertain date.
Your Honor, perhaps.
Go ahead.
I didn't mean to cut you off. I apologize.
No, go ahead.
With just to have a date down there, and I certainly understand Your Honor's concern there. Should we set it at? I believe that the transcript from the incomplete deposition of Alternatives Corporate Rep was prepared maybe. I think we received it maybe a week ago, I believe, which was roughly 10 to 14 days after the deposition was completed. Should we just set, with June 13th as a new discovery cutoff deadline, should we just set the summary judgment response deadline for 30 days after that, knowing that it's going to probably take 7 to 14 days for a transcript if we wait until, or if assuming there might be some depositions towards the end of discovery, and that would hopefully give us enough time, and that would be ballpark of like either Friday, July 11th or Monday, July 14th. That's just a proposal, so we have a firm date.
Any comment from any of the other lawyers regarding that proposed date?
No, Your Honor.
No, you're wrong.
Feel like we need a firm date, Your Honor. Yes.
Monday, July 14th. Right. I think it would be premature to try to set up a hearing date on the motion for summary judgment. I don't want to lose track of this case, and I want to have another date on the calendar to address the status of this case at some appropriate time in the future. Counsel, I'm contemplating perhaps one just after the close of discovery on June the 13th. At that time, we would at least know, I think, a little bit more than we do now. And I think that we could, at that point, then schedule an appropriate date after summary judgment response period expires for the actual hearing of that motion. I'm going to look at a June date. Monday, June 16th, Counsel?
Your Honor, that works for Boeing.
Okay.
Your Honor, I am hopefully going to be in Spain on that day.
Okay. When will you be back?
Should be back on the 22nd.
Okay. This court goes on vacation a short time thereafter. Ms. Shore.
Are you going to be in Spain, Your Honor?
I will not.
Oh.
Regrettably, I will not, Ms. Shore. We government employees have limited resources.
Yes.
I hate to put something in there. I was looking around that July 4th holiday. Probably looking at Tuesday, July 8th, Counsel. Tuesday, July 8th.
That works for Boeing, Your Honor.
We'll do 11 o'clock a.m. again.
Certainly, Your Honor.
Your Honor, I can make that work. That's great. All right.
And I'm going to look and see if there's any other issue that needs to be addressed today. Mr. Edwards, let me ask you first.
Your Honor, the only two other issues from our motion are, and I think we kind of touched on this, but I don't know if we fleshed out entirely, is the motion to compel complete discovery responses. We just request, kind of like what I mentioned earlier, that Mr. Bruce sit down with his client and go through the Roman numerals 1 through 5 from pages 14 and 15 of my motion, and either produce what has to be produced to satisfy those Roman numerals, again, which it includes all responsive documents, not just documents that he intends to use to support his claims. And then confirming in writing each of those issues, which are that he met with his client to talk about them, discussed each request and interrogatory with his client, that his client has searched for and compiled our responsive documents, communications, and information, that all of that has been provided by his client to him, that he's then produced everything, to us, and that if he's withholding anything, he provides a privilege log or otherwise spells out what it is that he's withholding, so we know it exists.
All right. I think on its face, that's a reasonable request, but I do want to allow Mr. Bruce sufficient time to accomplish that goal.
Yes, Your
And
Honor.
hopefully completely and for all purposes, those issues would then be resolved. I'm thinking about a month to do that, Mr. Bruce. Is that a realistic time frame?
Yes, Your Honor.
All right.
Okay, so just to make sure we're all on the same page, if we have a month then to do that, then is that going to put us in a pickle to try to squeeze, the rest of the discovery into a very compacted period of time? I just want to make sure everybody's realistic about our schedules.
It's 2.5 months remaining in the discovery period after that deadline.
Okay. Well, hopefully that should work.
All right, Mr. Bruce, your deadline is completely and for all purposes, those issues would then be resolved. I'm thinking about a month to do that, Mr. Bruce. Is that a realistic time frame?
Yes, Your Honor.
All right.
Okay, so just to make sure we're all on the same page, if we have a month then to do that, then is that going to put us in a pickle to try to squeeze, the rest of the discovery into a very compacted period of time? I just want to make sure everybody's realistic about our schedules.
It's 2.5 months remaining in the discovery period after that deadline.
Okay. Well, hopefully that should work.
All right, Mr. Bruce, your deadline is ordered by the court to be Friday, April 4. Friday, April 4. And then at that point, the documents to be produced should be complete as far as discovery and turnover of those documents. Everyone should know exactly what the documentary record of this case is from the plaintiff's perspective, and then further scheduling can be accomplished from there.
And Your Honor, just to be real clear, just so there's no confusion here, that would be for all responsive documents, correct?
Correct.
Okay. Thank you, Your Honor.
Your Honor, the only thing that might be an issue would be the expert, but I think we're going to get that in 28 days. So that should be workable.
All right. Very well. And Mr. Edwards, once again, I'm going to be tasking you with drafting an order stemming from today's proceedings, documenting the matters that have been covered by the board.
That sounds good, Your Honor. The only outstanding issue then, I think, with the motion compel issue is we had the last request for fees. I just wanted to raise that for the court just so we could, to the extent the court is so inclined.
I note your request, and I read that in your motion, Mr. Edwards. The court will take that issue under advisement at this time. I want Mr. Bruce to have an incentive here to fully comply with the requests made without sanctions. I really would just want to see voluntary compliance with discovery requests, which Mr. Bruce has unequivocally pledged. And the court will take I'm not going to deny your request at this time, Mr. Edwards, but take that under advisement at this time for later ruling.
Understood, Your Honor. Thank you.
All right. I think we've got Mr. Edwards' matters covered. Ms. Shore, is there anything else that we need to address today?
No, Your Honor. Thank you very much.
Have a good time in Spain.
Thank you.
Mr. Malone, anything further we need to address today, sir?
Your Honor, one thing, I've been sitting here listening to all of the issues about the discovery. One of the things that came up in the corporate rep deposition of Mr. Bruce's client was that towards the end of the deposition, he testified that at some point he had taken all of the unpaid invoices that were initially issued to my client and had them all reissued in Boeing's name. And I've yet to see any of those invoices. So when Mr. Bruce is looking for documents that his client says existed and were going to be produced, that might be something he might note.
That's a fair request, Mr. Malone. Mr. Bruce, anything you want to say about that?
I discussed that with my client, Your Honor, and I think the the invoices that he's talking about were sent to Boeing, but I don't know that they were printed out in Boeing's name. I will verify again whether that is so.
Well, he testified that they were at Boeing's request. So I don't know what he did, but that was what the testimony was.
You understand?
Okay. And Mr. Booth shall respond appropriately to that.
We will, Your Honor. Sometimes there's a good reason for a read and sign on a deposition.
Indeed. All right. I think the issues that need to be addressed today have been, counsel. Again, Mr. Edwards, if you'll journalize the matters that have been covered today, including the specific deadlines that have been established. Good luck, counsel, in working together to try to resolve all issues in the case, discovery or otherwise.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Very well. And if there's nothing further at this time, this matter will currently be in recess and the meeting may be ended for all. Have a good day, counsel.
Thank
Thank
you.
you, Your Honor.
Be safe, be well, sleep sweet, and much love.